All right.
Okay.
So I will go ahead and get started. My name is Taylor Burns. I am an attorney with ABLE, and I am here today with Reem Soubey, who is, I think, always here on the Ask the Attorneys. And we're going to be talking about criminal record sealing. Do you have anything else to add, Reem, before I get started?
Yes. So I just want to thank everyone for joining, and I want to thank the Junction Coalition for putting on these presentations with a lot of information for everyone, not only people in the Junction neighborhood, but everyone has access to these presentations. So we're grateful to the Junction Coalition for that. And we had a presentation last week about issues pertaining to probate and real estate. We have a presentation planned for later on in July on starting a business and how to structure your business. So we welcome people to continue joining us on the Ask the Attorney presentations. For most of our presentations, and particularly for this very important presentation, the criminal record sealing issue, we are taking on cases at ABLE at no charge to the clients. So if you have a criminal record that you would like to have sealed or expunged, and we'll get into the difference between that during the presentation, please go ahead and submit your name and number and request in a private message to myself or to Taylor Burns in the chat. If for some reason you can't access us, feel free to submit your name, number, and information to Alicia Smith, and she'll pass it on to us. You will then receive a call from our intake staff to open a case for you so that we can represent you in sealing or expunging your record, or if you're not eligible for either, we'll let you know if you're not eligible. Taylor is going to walk us through basic definitions and more complex nuances and analysis of what qualifies and what doesn't qualify for sealing. And then we will take some questions. Taylor.
Okay.
Reem and Taylor, on behalf of Junction Coalition's board and our community, we want to thank ABLE for having this time with us while we present Ask the Attorney. I just wanted to make sure that I knew that we are definitely interested in continuing these. So please, please, please respond on with any concepts that you like to ask the attorney. And thank you in advance, ladies.
All right, thank you both. So I'm going to go ahead and get started. So you'll notice that this presentation says criminal record sealing, and that's the term that I'm going to use throughout the time that I'm speaking. And there is a difference between expungement and criminal record sealing, and I will get to that in just a moment. But first, what I always like to start by talking about is why record sealing is so important to our community. So it's estimated that 1 in 11 adults has a felony conviction, and 1 in 6 adults has a felony or misdemeanor of some kind, and 1 in 3 people has a record of some kind. And I know that I am probably preaching to the choir, right? And folks know how this is impacting their neighbors, themselves, their family members. But these records are all viewable by employers and landlords, schools, and they really do impact folks when they are trying to move on with their life. We know that employers conduct background checks, that over 90% of them do. And the presence of a record lowers the chance of a callback by 50%, which is a huge number. And formerly incarcerated individuals are nearly 5 times as likely to be unemployed. And this is also an issue of racial justice. We all know that individuals of color, especially Black individuals, are disproportionately arrested, convicted, and sentenced. So it's really important to us as in our work to address those issues in the ways that we can, and record sealing is one of the ways that we can help address the issue on the back end, although it definitely needs to be fixed on the front end. So like I said, criminal record sealing in Ohio is often called expungement, but they are different, and this gets especially confusing for people because even though what we're usually talking about is criminal record sealing, even the courts don't use the correct terms, and a lot of their paperwork says expungement. But I want to be clear about what's going to happen to folks' records when they are eligible under these laws. So when a record is sealed, it's no longer publicly viewable. So it's basically locked away. It still exists, but it can be viewed by certain individuals for certain circumstances. It may appear on certain government issued background checks. It will still be considered if there's a subsequent arrest or there's charges, the prosecutor, the police could still look at that record. And then certain employers can look at the record, schools, nursing homes, places where someone will be working with the elderly, those types of places can still see sealed records. But for the most part, it restores rights and privileges for most purposes. Owning a gun, all of those types of things, those are, record sealing does address those issues. Now, expungement is when a record is no longer retrievable. It's like when a fire destroys it, like poof, it's gone. It is very rare in Ohio for adults to be able to seal their records. It's limited generally to juveniles. There's some weapons charges that are no longer criminal offenses, and then records relating to human trafficking. So there's very few circumstances under which a record could truly be expunged. Although, again, you'll hear courts use that term. And so it gets confusing, but I just want to be clear about what would happen with these records should you go through this process and get your record sealed. So although criminal record sealing is obviously related to the criminal case, here in Lucas County, public defenders do not provide representation in record sealing. There are a few counties in Ohio, like Cuyahoga, where Cleveland is, where the public defenders actually handle these types of cases, but they don't here. So people were left without very many options. It is a confusing process. So that's why we started doing some of this work. So what I'm going to go through today, there's different rules for sealing convictions and non-convictions for adults. And then there's also different rules for juveniles. And it gets easier as you go down that list. So I'm going to start by talking about convictions and non-convictions, and then Maureen's going to follow up a little bit with the juvenile records. So first, to seal an adult conviction, there's 5 requirements that you have to meet to be eligible. And I will go through each of these individually, but I just like to list them all out. So first, we're going to have to look and see, is someone an eligible offender? And I don't like that term, but that is the term that the law uses. So that's what the term I will use. You have to look and make sure there's no pending charges, that the offense is an eligible offense. So those are 2 different considerations, whether a person is eligible and whether an offense is eligible. We have to look at whether the waiting period has ended. And then the 5th and final requirement is that the applicant has to demonstrate that they have an interest in sealing the record, and that they've been rehabilitated. So again, the first requirement is that someone be an eligible offender. And there's actually 2 different pathways. So if you or someone you know applied to have their records sealed, 4 or more years ago, they may have been denied and may now be eligible. So make sure if you're talking with folks or you yourself have previously been denied, you may now be eligible. The Ohio legislature actually passed a new law, and then the law changed again in April. And this is one thing that they're doing well, and they keep opening the class of folks who are eligible to seal their records. So pathway 1 was the newer pathway that was created about 4 years ago. And under this pathway to becoming an eligible offender, you can have any number of total convictions. So there's no limit on the total number of convictions you have. And when we're talking about the total convictions you have, we have to look at convictions everywhere, not just in Toledo or in Lucas County or even Ohio. It's any convictions anywhere in the country. But you can have any number of convictions, felony or misdemeanor. However, the applicant can never have been convicted of any 1st, 2nd, or 3rd degree felonies. So those are your highest degrees of felonies in Ohio. Any offensive violence, and those things are specifically listed in a statute. Those include things like murder, robbery, assaults, some assaults, domestic violence, those types of things. Things like involve violence, right? But they are specifically defined. So some things are included that you wouldn't think should be, and some things aren't. And then any felony sex offense. So if you've been convicted of any of those things, you would not be eligible under pathway 1. But there's a second pathway, and it seems to be like a narrower pathway, but some folks are eligible under pathway 2 and not pathway 1. So pathway 2, to be eligible, an applicant can only have been convicted of 0 or 1 felonies and up to 4 misdemeanors, or 2 felonies and up to 2 misdemeanors. So the second pathway limits the number of total convictions someone can have, but it doesn't look at what the convictions were for. So usually when we see people eligible up here, they have a low number of convictions, but maybe they have a conviction for an offense of violence. So they weren't eligible under pathway 1, but maybe under pathway 2. There's some exceptions, and minor misdemeanors and traffic offenses do not count towards the total number of convictions. Was there a question, or? Sorry, I just heard some background noise. Okay, so this was the first step, right? Is someone an eligible offender? These are the exceptions I was talking about. It gets really complicated when you're looking at figuring out the total number of convictions for someone. So if someone had 2 or more convictions relating to the same offense, they may be counted as 1, or 2 or 3 convictions that resulted from the same indictment, but they were different but related offenses. So think about passing bad checks. If you pass 2 bad checks over the course of 2 months and had 2 different convictions for that, that can be counted as 1. So this is a pathway or an instance where it's really helpful to have an attorney going over your record and seeing if your record meets any of these exceptions. So if we've determined someone is an eligible offender, either under pathway 1 or 2, doesn't have to be both, either one, the next thing we're going to look at is whether there are any pending criminal charges. So courts will not seal conviction records if an applicant has pending criminal charges. And I think when people hear that term, they think of just, an open case. But that also includes paying fines and paying restitution and completing probation. So if there is any outstanding part of the sentence, which includes, jail time, probation, and restitution and fines, the courts will not seal any charges, even if that is not in the case that you're trying to get sealed. So it's really important to get all of those things completed, paid off, all of those things before you file, because you don't want your application denied, because there's any pending charges. So if someone's an eligible offender, they have no pending charges, the next thing that we're going to look at is whether the offense that they want sealed is an eligible offense. So most folks, when they come to us, they want everything sealed. So we will then go and look through all of their convictions and determine whether it's an eligible offense. So most offenses can be sealed. There are exceptions though. So any conviction that has a mandatory prison term, and those are going to be your more serious felonies. First and second degree felonies are never sealable. Traffic offenses are never sealable. And that is a really common question we get from folks who have a DUI or an OVI. Those are not sealable offenses. They are still considered a traffic offense, and traffic offenses are not sealable. Felony offenses of violence and then some first degree misdemeanor offenses of violence are not sealable. Some sex offenses, it depends on the degree of the sex offense and a few other things, those are not sealable. And another common one that we see that trips people up is any felonies or first degree misdemeanors if the victim was under the age of 16 at the time. And unfortunately, we see these charges in cases where maybe CSB gets involved, and there's some like neglect or those types of charges. And so if the child was under the age of 16 at the time, those would not be a sealable offense. So once we've determined that which offenses are eligible to be sealed, we're going to look at and make sure the waiting period has ended. The law change that just went into effect in April actually decreased these waiting periods, so that was really great. So there's a 1-year wait after a misdemeanor is discharged, a 1-year wait after a felony if it is a 4th or 5th degree felony, and then 3 years if it's a 3rd degree felony. And when I say that the wait is 1 year after discharge, what I'm talking about is discharge means that jail and prison sentence has been served, terms of probation and parole have been served, and any fines and restitution have been paid. I will say, this is what the law says. We have seen courts that don't pay too close of attention to when fines were paid. Sometimes if the fine was just paid, they will still do it. Technically, they are supposed to wait a year. They will not do it until a year after probation or parole has been served. But that is a place where there's been a little bit of gray area with how our courts are enforcing this law. Court costs are not part of a sentence, and unpaid court costs are not an absolute bar to sealing. So before I talked about fines, meaning that there's an open case or pending charges, and here I say fines have to be paid for a conviction to be discharged. That doesn't include court costs. Court costs are not technically part of the punishment issued for any type of conviction. But some courts and some judges will look at court costs. So when I'm working with a client and they have outstanding court costs, what I will do is warn them, say, hey, the court may look at these court costs and say, that you can't seal until they're paid off. And that is something, they can do. They have discretion. Even if you meet all of these criteria, it's ultimately up to the judge whether or not to seal the record. So this is an area where I always recommend folks to pay if they can, work out a payment plan, or perhaps even just get on a payment plan before they file to seal, but it's not an absolute bar. So, and the fifth and final element is an applicant has to show that their interest in sealing the record outweighs any legitimate government interest in maintaining the record, and they've been rehabilitated to the satisfaction of the court. So for the interest in sealing the record, what most folks will do is talk about in their application and at the hearing, that they are applying for housing, they're applying for employment, and that the record is preventing them from accessing those things, maybe preventing them from accessing education. Maybe the record just isn't reflective of who they are as a member of society anymore, any of those types of things. Folks have to explain why they want their records sealed. I will say that this may be a motivation for some folks, but telling a judge that you want to seal the record because you want to get a concealed carry permit, probably not going to convince the judge, right? That could be a motivation, but that should not be the only reason that you talk about in your motion or in the hearing to convince the judge that he or she should seal your record. Talk about employment, housing, those types of things. And then, when we're talking about showing rehabilitation, a lot of times I will, have a client talk about how long it's been since they've been, involved with the criminal justice system. Have they been maintaining employment? Have they been volunteering? Have they been engaging in mental health or addiction treatment? Are they involved with their church? Have they been raising their family? Any of those types of things that I think people think, oh, a judge doesn't want to hear about those things. They really do. It's really important that the judge sees you as a human being, as you are, not just as a record on a piece of paper. And that can go really a long way in these hearings and convincing judges that they should seal the record. Because again, it is in their discretion as to whether or not to seal the record. So the more information you can provide about what you've been doing since the conviction, it's just really, really helpful. So how the application process works when someone's applying to seal their record. So they have to apply at the court of convictions. So if you have a conviction in Lucas County, common pleas, you have one in Toledo, one in Sylvania, those are all going to have to be separate filings. So every court where there is a conviction that needs to be sealed has to get its own filing. Generally, there's a $50 filing fee, and that should be per filing, not per case. So if you have 6 cases in Toledo that you're applying to get sealed, it should still only be one $50 filing fee. If it's not, if courts are telling you something else, which we have experienced that they sometimes do, definitely want to hear about that problem. In addition, I know $50 is a lot, especially when we're talking about that $50 you had to pay at each different court. There are poverty affidavits available at the court and generally online that can waive those fees. So I believe it's either 167% of the poverty line or 185% of the poverty line, which you can look up online. So if you're under that, you wouldn't have to pay that filing fee. So those are available. at each court if you're unable to afford that fee. So then what happens is once that the application is filed, it has to be sent to the prosecutor as well. And then the court's going to schedule a hearing. And it is super, super important to attend that hearing. It is very, very unlikely that a judge will seal the record unless the applicant shows up to the hearing. And usually what happens in that hearing is the judge will, consider the application, look at whether someone's eligible, and then want to hear from the applicant why they want to have the record sealed and, whether or not they've been rehabilitated. And after that hearing, the judge will make their decision. And if they decide to seal the record, it does take a few weeks for them to get the order out and get it sealed, and seal it at the police department, at the court. It does take a little bit of time to get those records all sealed. So that was all about sealing adult convictions. So now I'm going to move on to sealing non-convictions. It's very similar, but it's a little bit easier to get a non-conviction sealed. So there's 4 requirements. The first is that all charges were dismissed or acquitted. The second is a waiting period. The third is no pending criminal charges. And the fourth is the applicant's interest. So the first requirement is that all charges were dismissed or acquitted, or the person was acquitted. So when I say dismissed, I mean the prosecutor dropped the case or the judge dismissed the charges. Acquitted is when someone is found not guilty by a judge or a jury. So what trips people up sometimes when they're trying to get their non-convictions or dismissals sealed is if someone is convicted on one or more of the charges that arose from one incident, they can't get the other charges dismissed, or they can't get the dismissed charges sealed unless they're eligible to have the conviction sealed as well. So an easy example of this is, let's say someone was arrested and charged with shoplifting and resisting arrest. So this all happened, at Kohl's, shoplifting, resisting arrest. During the criminal case, let's say the resisting arrest charge was dismissed, and then they were convicted on the shoplifting charge. That person cannot just then go and file to have the dismissal sealed quite yet. They would have to wait the 1 year before the conviction was eligible for sealing. So if there's a dismissal tied to a conviction, you need to wait until that conviction is eligible for sealing. Otherwise, any dismissal or acquittal, they're all sealable. You don't have to be an eligible offender. There's no dismissals that are excluded. As long as all of the charges were dismissed, they are sealable. So it's a little bit easier from analysis. There's just that one little hiccup there that can trip some people up. So for the waiting period, if there was a grand jury used to decide whether or not to indict, there's a 2-year wait after the issuance of a no bill. So 2 years after a no bill, if there was a grand jury, grand juries are generally only used in felony cases. So if you have a criminal record, I don't even know what that means, there probably wasn't one in your case. For cases dismissed without prejudice, which are generally most criminal cases, under the law, the court's not supposed to seal them until the end of the statute of limitations. So every criminal offense has a length of time at which someone could be charged with that offense after it's been committed. To explain it very briefly, it usually ranges from a couple of years to a longer amount of time. I will say that this is the way the law is written. This is, exactly what it means. However, judges sometimes will seal without really considering when the statute of limitations ends, especially, sometimes they're very, very long. But, just want to put that on your radar. So in order to be eligible to seal non-convictions, you cannot have any pending criminal charges. Again, this is the same way. Pending criminal charges are defined the same way as they are for convictions. So it includes paying fines and completing probation. So if you are on probation or owe outstanding fines, complete the probation, pay the fines off before you file to seal anything, whether you were convicted or the charge was dismissed or you were acquitted. And then finally, the applicant has to show that their interest in sealing the record outweighs any legitimate government interest in needing to maintain the records. And this is generally the same, line of reasoning that I talked about before. So, interest in employment, housing, those types of things. We know from experience that folks are often denied those opportunities, even when they're not convicted, right? Just because that shows up on a background check and it shows up on an application, even if someone was not convicted, it still can impact their future. And so it's really important to explain to the court how that's impacting you, if it's prevented you from obtaining housing or furthering your education. So this is a similar application process. Again, you have to apply at the court where the charges were brought. So if you had charges in Sylvania, in Toledo, Oregon, you're going to have to apply at all of those different courts. Generally, there should not be a filing fee. Some courts do try to charge, I think it's me in Lucas County here that tries to charge $50. Most courts know it should be free. But each court, again, if they are trying to charge for non-convictions, they should have a poverty affidavit available. Same rules apply here. You fill out your financial information, give it to the court, and they will determine whether or not you're eligible to have that filing fee waived. So as Rain was explaining, we are taking criminal record sealing cases. So what we are doing is we are currently operating a virtual clinic with the Toledo Bar Association. So if you or someone are interested in getting their criminal record sealed, you could contact Reem or I, or you can contact our legal aid line directly. And so what happens then, just to give you some background on the process, so our intake will take your information, including your name, your financial information, make sure you're eligible for our services because they are all free to our clients. Make sure you're eligible. They will get some more information on what courts you have convictions in. And then once they have that information, they will send it to the Toledo Bar Association, and they will assign you to a volunteer attorney or potentially even one of our able attorneys. That attorney will help you will look at your record, see whether you're an eligible offender, what offenses are eligible, and they will complete the paperwork. Once they've completed the paperwork, they will send it to you or they will arrange for pickup. And once you have that paperwork, then you will be responsible for filing it on your own. So our representation in most cases ends at completing the paperwork. There are cases where maybe it's a tough issue, or maybe it's questionable whether someone is eligible. In those cases, we would consider taking you on for full representation and representing you at the hearings. But for most folks, what they really need is help figuring out whether they're eligible and completing the paperwork. And then they're able to take those final steps on their own of filing the paperwork and attending the hearing. So if you are interested in that, this is the line to call, or the place you can put your application in online. And then I think Reem was going to talk a little bit about sealing juvenile convictions.
Yes, thank you, Taylor, for that great presentation. So I'll just speak very briefly about juvenile records, and then we are happy to take questions after that. As Taylor explained, there's several categories of records that are eligible, records that are not eligible. When it comes to convictions and records for someone who is a juvenile at the time of the offense, all such records are eligible to be sealed with the exception of murder, aggravated murder, and certain sexual offenses. So when it comes to juveniles, it's broader. The limitation of what is sealable is much broader. And then the other important aspect about juvenile records that differentiates them from adult records is that they are eligible to be sealed 6 months after the final discharge, which means the last fines are paid, or the last day of probation is over, the last day of serving time is over. So if you are, and Alicia did mention that there may be some individuals with juvenile records or individuals who are juveniles who might have criminal records that may be interested in sealing, please do reach out so that we can assist you. Now, the other thing I want to mention about juvenile records is that they can be expunged. So juvenile records should be, once they're sealed, they're immediately eligible for expungement after being sealed. And as a refresher, if you weren't paying attention, expungement is when the record is completely destroyed versus sealed is when the record is separated from the general files and kept in isolation and prevented from the reach of certain background checks. Expungement is when the record is completely destroyed. And so for juvenile records, they are eligible to be expunged immediately after they are sealed. There is one last thing I want to mention about juvenile records, is that there is something called automatic sealing of juvenile records. It means that these specific records that I'm going to list are going to be automatically sealed by the court without an application by the juvenile. And I want to say that even though that is the law, if you do have one of those records that I'm going to list, it's still important to follow up and make sure that the court did what it was supposed to do, because it's you who is being impacted by the existence of those records, and errors do happen, mistakes do happen, and sometimes things go unchecked. So I'm going to list the types of records that are automatically sealed for juveniles. Unofficial cases, so if there was just an arrest or if there was a complaint that was then dismissed. Situations where there was police contact, but no complaint was filed and was not brought to the court. Cases that were referred to a diversion program, which was then completed successfully by the juvenile. Cases that were dismissed after trial when the juvenile was found not guilty. And unruly cases. So cases that had unruly convictions where the juvenile has since turned 18 and he or she has no other pending delinquency matters. I know that's a lot. I don't expect you to memorize it, but these are, this is an overview, what we provided you with to trigger your thoughts about what you should contact us for, and to invite you to let us assist in ensuring that criminal records are being sealed and that people's future employment, future housing applications are not hindered due to the existence of criminal records. I see Taylor has a wonderful PDF that she pulled up. Taylor, you're muted.
Taylor, you're muted.
Sorry, my computer froze while I was muted and I couldn't get my mouse to move. Okay, so thank you. Reem did hopefully list the convictions for juveniles specifically. I didn't do that, for adults, because if you see this list here, it is very long. This is a document that the Ohio Justice and Policy Center put together. I cannot take credit for it. I wish I could, because it is the most helpful document. I will send this to Alicia and hopefully she can put it on Junction's website or on their social media so folks can have access to it. And it really just goes through what I explained. And it's just very helpful, in determining whether you're an eligible offender, but it lists out those offenses of violence that I was talking about and those sex offenses. So if you have an offense, you're like, well, I'm not sure if this was on that list, the offenses of violence that she was talking about, I'll make sure to provide this to Alicia so that you can take a look. But it just goes through what we all talked about in a nice, organized way that I think a lot of folks will be able to follow along with.
And as we wait for questions to trickle in, I want to mention that even though it's not a criminal record, But eviction records are another barrier to housing and employment and other advancement of opportunities. And it is something that the Toledo court is now accepting applications for, and it's something that we do assist with at our office. So if you have an eviction record and you want to get that sealed, you're also welcome to reach out to us for legal representation.
And I just wanted to let the audience know that we did put our link, our website link in the chat box. And as soon as we get that information from Taylor and Reen, we'll put that onto the website. You'll also find the links to the recorded information for this Ask the Attorney, our previous Ask the Attorney, which was about probate and housing. And the one prior to that was about students' education and IEPs. So we are so very thankful to be able to host these events. And if you have any questions, please feel free to ask at this time. We do have a question. And that question is what all do we have to do it, to get the record expunged, is what I'm thinking that Miss Militia is asking. Reen?
So if you want to, if you're interested, and after hearing this, you think, oh, I might be eligible, I would encourage you to, like Reem said, you can either call the line that I had, the number I had provided, or leave your name and number for Reem and we can have our intake line contact you. And what they will do is then just get your information, again, your name, your financial information, and make sure you're eligible. And then they'll want to know the courts where you have conviction. So it's pretty important to try to think through. I know a lot of folks may have older charges, and sometimes it's hard to remember where they have convictions. But if you can think through where you have convictions, be ready to provide that information. And then we take that information and kind of get running and get it all together for you, figure out whether you're eligible, complete the paperwork for you, and then provide it to you. And then you would just, go file it and attend the hearing. So, what you have to do to get it going is basically reach out to us and, get the intake started.
So I want to add, when we're talking about the sealing for criminal records, most of those applications are discretionary, which means that the court has discretion or decision-making power to decide whether to allow that record to be sealed or not. There are some automatic sealings that happen for juvenile records that I mentioned previously, but most of the sealing process of records and the expungement, the sealing and expungement process is mostly discretionary. I did see a question asking about who can access your records. I'll let Taylor respond with regard to adults. As for juvenile records are not public information, so they're not supposed to appear on background checks. Sometimes there are certain circumstances where BCI reporting has pulled those records, but they are usually not supposed to appear, and they usually do not appear on background checks. However, there are 3 exceptions to that with regard to juvenile records. Again, they are the same exceptions that I listed earlier, which are not eligible to be sealed, which are murder, aggravated murder, and certain sexual offenses. So these are, with regard to juvenile records, the only records that appear on background checks.
And for adult criminal records, anyone can get copies of that unless they're sealed. So if I know your name, I can look your name up in any court's website, pretty much any court's website, and look and see, what your criminal record is. In Ohio, each court maintains its own records, so I'd have to do that for every court. But I could look it up just knowing your name. There are companies that mine that data, so they collect all that information and they report it out. That's what a lot of landlords and employers use. So pretty much anyone can access an adult criminal record unless it's been sealed. And then once it's sealed, only certain agencies can access it. And that would be like prosecutors and law enforcement if there is another arrest or a charge. And then certain employers like schools. So if you applied to work as a teacher at a school, or if you applied to work as a nurse in a nursing home working with the elderly, those types of employers can see those records sealed once they are sealed. But unsealed records are viewable by everyone.
We do have another.
Sorry,
Go
go
ahead.
ahead.
No, please.
So I see another question here. If you're ineligible for ABLE services, is there a cost or do you make a referral? So we cannot charge for any of our services. If you're not eligible for us, the Toledo Bar Association can usually make a referral. There are private attorneys who will do these cases for a fee. I don't know exactly what their fees are, but there are private attorneys that the Toledo Bar Association can recommend.
We have one additional question in regards to Kayla. Kay, I'm sorry, was asking if she doesn't any longer reside in Ohio, but would like to go about getting her record sealed. How does she do that?
So, Ray, do you know if I'm actually not positive someone has to live in our service area to get our services? I thought they were, but Reem, do you know the answer to that?
The answer to that depends on our grants. And so we would still encourage you to apply for our services, and we'll check if there are any grants that would allow us to provide assistance to you, even if you don't reside here, and we'll let you know.
And I'm putting my email in the chat for you, Malaysia. And then hopefully if you can't get your message, oh wait, I just sent it to just Reem. I'm gonna send my email in the chat. So that way, if you can't get it to post you don't wanna post your number out there for everyone, you'll be able to reach me or Reem. So it's there, it's tburns@ablelaw.org.
I just want to
Any other
take this.
questions?
I'm going to take the time. We have Kayla Preston, who is our manager for community outreach for Junction, and then Devon Fagan, who does a number of our social media release information, and thank them for getting this information out to our public and having these good questions come in. And do go and visit the website. This information will be available to each and every one of you. This is about you cleaning up and getting what you need done with the attorneys. Ask the Attorney series is for your benefit, our community working together. I'm thankful to have our board online and a number of our directors as well as our public. So thank you, ladies, for all of the work that you've done to get this going and get this started. I don't want to cut off any questions. I just wanted to make sure that I said thank you while folks were still on. So any additional questions? I agree with Ramon, our organizer, that we want to get this out far and wide.
Yeah, and thank you for having us. We appreciate the opportunity to reach our community and tell them about this important issue. Like I said, the law changed a few years ago, and so many more folks in our community are eligible for this. It's a really wonderful thing, and we want to get as many people, to get their records sealed as possible.
Wonderful. Well, Reem, do you want to share with everyone the next Ask the Attorney? And so folks can get that information out to the public. We're going to be making sure that we begin to market that on tomorrow.
Yes, give me 1 second. Let me pull up the exact date for that. Okay, so it's going to be on the 19th. We are going to have a presentation at 7 p.m. and we're going to talk about businesses. We'll talk about business structure, how to structure your business, what makes sense, what doesn't make sense, and what immediate steps you should take when you're thinking about starting a business. What paperwork you should get together, who you should talk to, what you need to think about, and what documents you're going to need to file to become officially established as a business owner.
Wonderful. So much is happening in the Junction community, our business folks, our children, our elders, and we are so thankful to have Abel working with us. Ask the Attorney, monthly series, sometimes bi-monthly, but together we can do better in Toledo. Thank you all for being with us. Taylor, always a great pleasure to have you with us. And Reem, we're so thankful for you taking good care of our legal needs. So please don't forget to continue to send messages to Junction if there's things that you'd like to ask the attorney that we have not covered, and visit our website where there's information on upcoming events. Have a wonderful and blessed night, and thank you all.
Thank you.